The US has no specific articulated law or regulation against insider trading. It relies instead on general SEC provisions and judicial opinions of over the last 5 years. India explicitly prohibited insider trading in 1992, and now, 23 years later, it has rewritten the regulation to expand the definition of insider, provide perpetual insiders a trading opportunity, and legitimize the communication of inside information for the purposes of transaction or investment-related due diligence. This new regulation will come into effect in May and will hopefully better equip SEBI to go after insider traders. But have we gone from too little power in the hands of SEBI to too much power? To answer that, I have with me Tata Group's Bharat Vasani, Cyril Shroff of Amarchand and well-known Counsel Amit Desai. Gentlemen, to all three of you, a very warm welcome to the firm. I'm going to start first by asking for what you make of this regulation in its entirety before we do a deep dive into specific provisions. The big picture view. Mr. Shroff, can I start first with you?
So the fact, Menaka, that we've revamped the insider trading code is a welcome development, because one of the scourges of our market has been that there has been this rampant insider trading, and there were a number of loopholes in the prior version of the regulation which needed to be corrected. So the heart of this regulation, I think, is in the right place. The intention is very clear: to make the market more secure and to bring the wrongdoers to book. Now, having said that, I think in terms of how the regulation has actually come out after a long process of discussion, is that it achieves some of these objectives, but there are a vast number of unintended consequences which are going to have a profound impact on deal making. They might have a profound impact actually on even innocent people who might be sort of unfortunately caught in how this could work, and may in some respects have actually created unintended defenses which SEBI may not have thought of how broad they are, and we can, in the later part of this panel, we can sort of discuss this. So I think it's too early to judge whether this is going to achieve the desired objective, but it sort of it started off on the right journey, but whether it reaches the destination or not, I have my doubts.
Mr. Vasani, you want to add to that quickly?
I would just say that, when you have appointed an expert committee with eminent people, and they've taken a trouble of drafting the regulations, and then after almost a year, without giving any justification or rationale of why you are departing from this recommendation and giving the new regulations, which in my opinion could have been much better, it's a disappointment on that count, that they should at least explain why some of the recommendations were disregarded. There is a very fundamental shift made now, which will be tough for the corporates and large corporate houses, is that now communicating UPSI, unpublished price sensitive information, itself is made an offense.
Right.
And we are dealing with 560,000 employees and large number of officials. Mere communication, up till now, in 2002 when the SEBI amended the insider trading regulations, they brought out a press release. And they said very categorically that if you are communicating UPSI is not an offense, it's only trading based on the UPSI is an offense. Now they have made it abundantly clear in Regulation 3 that just communicating, even if no trading or dealing has happened, itself is a...
But in 1992 regulations, it does say that no insider shall communicate, counsel or procure directly or indirectly any UPSI, which is unpublished price-sensitive information, to any person who, while in possession of such UPSI, shall not deal in securities. So it's sort of a twisted...
No, but dealing was a very critical part, and if you see the SEBI press release of 2002, it categorically said that unless you deal with it, communicating is not an offense. Now, for the first time, they have made communicating an UPSI is an offense. And I think that by expanding the scope of the connected person, they have created several situations which only time will tell as to how it is going to play out. But it's too wide a definition to be, I think, regulated. In fact, I think SEBI itself will find it too difficult to regulate this kind of definition.
Okay, I'm going to get to that in just a bit. But Mr. Desai, you want to add quickly, big takeaway from this?
Yeah, so give me a different perspective of this. So whilst you see that there is some good which has come out of this regulation, and I think it's, as Cyril rightly mentioned, that it's got the heart in the right place to try and deal with this scourge. The issues I think that the regulator are going to face in the context of trying to investigate and discharge the burdens that they've taken upon themselves in this regulation are going to be extremely onerous on the department.
Okay.
So at the end of the day, I think I wonder whether they would be very successful in actually trying to ensure that the scourge that they sort of started out to deal with, they will effectively be able to handle with this kind of a regulation.
That's interesting that you say that. Because I thought that the effort to rewrite this was also to give SEBI more power, combined with the new powers they have under the SEBI Act, to go after insider traders, more effectively. And I'll tell you why. As you just heard, the Prohibition of Insider Trading Regulations 2015 increased the restrictions on the communication of unpublished price-sensitive information and prohibit an insider from trading in securities when in possession of unpublished price-sensitive information. Now, an insider means any person who is connected or is in possession of unpublished price-sensitive information, or UPSI. This definition of insider is similar to the 1992 definition, but the definition of connected has changed dramatically. Earlier, a connected person included a director, officer, employee, or those with a professional or business relation with the company, which may give them access to UPSI. The new regulation adds to that list anyone who is associated with a company, not just via contract or fiduciary duty or employment, but also via frequent communication with the company's officers. The list of deemed connected persons is similar to the old regulation, except that it alters relative to immediate relative, including spouse, and financially dependent parents, siblings, or children. So, will this expanded definition of connected person, and hence insider, help SEBI cast a wider net?
I think the answer is yes, because it's a qualitative expansion of the definition by virtue of the frequency and the intensity of the sort of relationship or connection with the company. So it certainly broadens the net. But whether something is positive or not, I think we should judge it and evaluate it with reference to the object that is being sought to be achieved finally. So if the object is only to expand the net, I think I would give it a tick and say it achieves that. Finally, what is the impact of that in terms of how you'll be able to bring a charge, a legitimate charge, and be able to establish it, I think is the latter part of the conversation.
You know, there have been cases previously, sir, where people known to be close to, sort of group heads were accused of insider trades, and they just claimed that they had no official position, and therefore they were not within the definition of connected under the earlier regs. This new definition of connected, by saying that even if you have frequent communications with someone who is in a position of power in a company, you become a connected person, plugs that loophole, which gives SEBI more power, doesn't it?
Absolutely. And so they have migrated from position-based insider to
association-based.
Absolutely. But while they widened the net, they've left a big hole inside still. Which is? Which is that Sodhi had very rightly recommended that public servants should be covered. All of us are aware that, when companies file their advance tax payments, they make advance tax payments. They filed FIPB application for new projects. There are public servants and SEBI officials in case of many other transactions. They have become privy to unpublished price-sensitive information. There is an evidence that there is a trading based on those information.
But they come within this connected
because it covers person.
But the definition of public servant, which was there as a part of the SODI's recommendation, and the fact that specifically the connected person definition including public servant, that has been taken out.
That has been taken out, which indicates being politically correct, but not necessarily being legally opposed to the concept.
Because I think the definition of person is broad enough to pick up all of that.
Yeah, but I think the problem that we're going to face is if you look at the definition, the expanded definition of connected persons, they have been cautious to try and exclude the public servant from this.
Yes.
Because if you look at it, the qualifications that have been put, whilst it is qualitatively wider, what the qualifications that they put are who are directly or indirectly in any capacity, including by frequent communication. Now, a public servant may not be in frequent communication with a connected person by any contractual, fiduciary or employment relationship. A public servant is in none of those, or a director, officer, and employee of the company, or holds any position including a professional or business relationship between himself and the company, temporary allows, etc. So what you have effectively done is if excluded the public servant by process of this interpretation.
In which case, sir, he would fall under the second, criteria to make him an insider, which is that he would be in possession of UPSI.
Yeah, so
he may not be a connected person, which is a very wide definition. But by having that information, if he knew with something that the marketplace didn't know, and he traded on the basis of that, he would still be an insider trader.
But
so they don't escape the net, they just don't get the specific mention that was there in the committee.
But they will use it in the defense that the objective was not to cover the public servant, and that's why this was.
If you use committee reports in your defense in a court of law,
it has been used in the past.
Really?
It has been used in the past in Supreme Court for so many cases. Anyway, so coming back to that, so that was one of the things which I thought was missed out in the definition of connected person.
Okay.
But I am very worried about this frequent communication. You can have frequent communication with a person which is completely unconnected with company's functioning to a friend or someone else, and now you are virtually making that person connected person, and God forbid if that person were to trade during that period when some M&A transaction was to happen, completely, he has to prove his innocence now. As you know, there's a reversal of burden of proof. It will be a tough one for the person just because he's in constant communication with some official of the company.
Therefore, the example that you gave is that whilst the attempt has been made to sort of reduce the number of relatives by bringing in the aspect of immediate relative and those who are not financially independent, what happens with their relatives? Frequent communication. No. So you bring that. So how do you determine? Because the question is that whether the communication is relatable to the question of insider information.
I'll just give you an example. I have so many friends with whom I discuss only Hindi film music. And we are frequently in communication, and unfortunately that person was to trade in any of the Tata securities, and there was a transaction going on at that time.
But surely they
the
don't
old data records, which SEBI has a power now.
Social communication, surely they mean frequent official communication.
There's no reason to assume that they don't mean that.
But they don't mean that. If you see, and SEBI now has acquired power to get cold data records, they will figure out that there is so much of communication with this person.
But they don't know exactly what you're talking about. They don't know you're talking about Kishore Kumar and not Tata Steel acquisition.
Absolutely.
The definition of connected person and insider has been expanded to cast a wider net. And the burden of proof has also shifted. It is now up to the connected person to prove that he is not connected with the company and hence does not have access to UPSI. Whereas in the case of those not connected but charged with having traded while in possession of UPSI, SEBI has to prove the possession of UPSI. Does this shift in burden of proof make it tougher for those accused to defend themselves? Amit Desai says, on the contrary, SEBI has provided the accused with a jumbo defense.
In fact, it makes it that much more easy to defend themselves.
Why?
Because because what has happened, and I think that's a dramatic change in this particular regulation, is so far as an insider who is not a connected person is concerned, the burden of proving that he is an insider in possession of the price-sensitive information is on the SEBI.
Which was the case earlier as well.
No, because earlier the SEBI used to take a position saying that the burden shifted. The defense that they have now brought in, which is in the proviso 241, is that the insider is entitled to prove his innocence through a set of circumstances. Those circumstances which are not actually defined in the Act actually would suggest that if there's an absence of a mens rea, so you didn't do it for the purpose of committing the fraud on the capital market, which is really the underlying intent of this particular regulation. You did it, for example, you need it for medical expenses. So you sold some shares for medical expenses. You need it for a marriage in the family. Then those are circumstances which are extenuating circumstances. There are defenses that are now available to such an insider in relation to...
On what basis are you saying
that? Is because in 4.1,
corporate purpose may be also
which might extend.
So explain to me how you reached this conclusion, sir.
So if you look at 4.1
proviso.
and the proviso to 4.1, which says that provided that the insider may prove his innocence by demonstrating the circumstances including the following. So there are a set of inclusive and illustrative defenses which are there. But when you talk about proving his innocence, the innocence is only in the context of what the regulation intended to achieve. So what you did was you're saying, I didn't intend to commit the offense of insider trading.
But if you look at the outs or the innocence demonstrations that they've offered here, they're very strict. For instance, they've given you the illustration of you can prove your innocence by demonstrating that the transaction is an off-market interstate transfer between promoters, both sides of whom were in possession of the UPSI. Or if you were a non-individual insider, they have said you can prove your innocence through a series of steps which show that the individual who traded was not the same as the individual who had the UPSI, or if there were, the same, there were Chinese walls between the two. These are illustrations.
They're not illustrations of innocence. They're just specific carve-outs. So I think there is a fair amount of...
So any out that anybody uses in his defense... No, but any out would have to be as serious as this, wouldn't it be? Can they use the out that, someone in my family fell ill, they would have to show that that person was critically ill. But someone in my family fell ill and I sold on the basis of that. And if that's the reason why you sold, then isn't that not insider trading?
Circumstances. It could be I think it could even be, I needed to exit from this business to liquidate it and reinvest it in a good, legitimate other purpose. Sir. Why is that not innocence? It's a valid corporate purpose. So long as it is not fraud on the market, everything else I think is innocence.
So you're saying that if you were a connected person who had UPSI and you could demonstrate that you sold for this legitimate corporate reason of wanting to use your capital elsewhere, then you would be able to use that as a valid defense and SEBI would not be able to win in a case of this nature?
Right. And that is something that we actually tested in a matter of Rakesh Agarwal, which was about 10 or 12 years ago, where the facts of the case were that it was actually for a larger corporate purpose. He was bringing in a 51% investor into the company. He was about to make an open offer. He found that he was not in a position to actually garner adequate shares for offering his 20% into the open offer. He then went into the market, bought and put those shares into the open offer in order to ensure that the company actually survived. All stakeholders benefited from that. He ultimately succeeded in SAT. And SEBI actually had taken that matter to the Supreme Court. Ultimately, it got settled. So there was no final determination.
The last word on the subject is he won.
The last word
essentially what you're saying is that what SEBI may have gained by expanding the definition of connected person, it has lost by allowing for this one out, this one line which says you can prove your innocence.
It's a very big out.
It's a very, very big out.
Okay, so now let me come back to your concern. You said that you were very concerned that even frequent communication could get you into trouble. So, if you were to do this to the connected person's definition, which is expanded so that SEBI has more powers, then don't you think it's only fair that the regulator has done what it has done, which is that given you several defenses as well?
I am happy with the out.
So absolutely. Don't the two get balanced?
All of us are very happy with the out, absolutely.
We have a blunt weapon over a larger number of people.
But I don't know whether it's done with an intention to give the out, or is it come out this way? I don't know. Because there is no debate, there is no discussion. Up till now, the doctrine was of strict liability. There is a doctrine of strict liability. In fact, that's another part.
There are some notes.
Some notes are there, but Sodhi committee had very categorically stated and inserted that the note should be treated as an integral part of the regulations. That note has been deleted.
So it says here the note to the specific section that Mr. Desai pointed out.
The person who has traded in securities has been in possession of UPSI. His trades will be presumed to have been motivated.
Yeah, there is a note.
The reasons for which he trades or the purpose for which he applies the proceeds are not intended to be relevant for determining whether the person has violated the regulation.
So they exclude that mens rea defense by saying the reasons are not relevant.
The last sentence is, once established, we open to the insider to prove his innocence by demonstrating the circumstances mentioned in the proviso.
But that's when the reasons come in again.
No, so mens rea is back.
That's right.
Mens rea is absolutely back, which was not the case hitherto. It was a doctrine of strict liability.
It is not only back, but it has been reiterated by the note.
No, it has been removed by the note and then reiterated by the note. Because the note in one part says reasons for which he trades or the purposes to which he applies are not intended to be relevant. And then it says it's open to the insider to prove his innocence by demonstrating the circumstances mentioned in the proviso, failing which he would have violated the provision.
And that is why I think the regulator was right in saying that the notes will not be relevant for the purpose of interpretation.
Because they are confusing notes as opposed to being simplified.
I have a big issue with the use of notes as a sort of a legislative or a regulatory tool in this, especially where in some cases it actually contradicts. This is one example. There are several examples.
So what have we got here? We've got a more expanded definition of connected persons that allows SEBI to go after a lot of people that were slipping through the cracks, to be very honest.
Which is a good
thing. But we've also got now a bunch of new defenses that these people could use
to show
legitimate reasons for the same.
You've got a jumbo defense which you can stretch in whichever way you like.
But is it all bad? Because if they had done only one part of this, which is expanded the definition of connected persons, then it would have seemed very unfair without giving people defenses.
So I think I look at it from 2 points of view here. If you look at it from the point of view of dealing with transactions, protecting the capital markets, etc., I think it's not. If you look at it from the point of view of an insider who has actually taken advantage of the regulation, it's a great out for him. So ultimately, did you achieve the object that you set out? Because some of these regulations which come in, I think necessarily have to come in with a sense of strict liability, because you have to achieve a larger objective in this process.
Mr. Desai, if they would have come in with a strict liability, if these defenses were not provided for, you'd be arguing the other way around, saying, how can you tighten the screws on connected persons in this fashion without offering any defenses? This is not an authoritarian state.
If you wear the hat of a defense lawyer, then of course it's fabulous.
If you wear the hat of SEBI's counsel.
But if you wear the hat of a regulator who's trying to achieve and ensure that this scourge in the market, and today what is happening in India is well known to the regulator, then you would normally at this stage not give this out.
Or you would give specific outs.
Or you would give specific outs. And in fact, in many of the legislations outside, there are very specific outs.
How many outs can you list? This kind of capital reallocation is an impossible out to list. You can list medical emergencies in a family. But how many outs can you list? Human minds will come up with all kinds of
We are all very happy. We are all very happy.
Among the many new definitions is the definition of trading that replaces dealing in securities. Trading now includes dealing to align itself with the words used in the SEBI Act. That's all fine. But the accompanying explanatory note says the definition of trading now also includes activities such as pledging when in possession of unpublished price-sensitive information.
The way dealing has been expanded in the note to include pledge of shares is a huge, profound impact on
financing.
People do
I don't know whether the bankers in the country have seen it. They'll be jumping off their seats when they
absolutely that you all the time pledge your shares of the listed company as a security for getting loans from the banks, and how the entire sector is going to get impacted if you have to put all the UPSIs which you have in public domain before you can pledge the shares.
But if you pledged while in possession of unpublished price-sensitive information, isn't that in some sense also insider trading?
No, when you look at a financing transaction, put yourself in the position of a bank or an NBFC who is lending money against shares. He is simply concerned with the value of the security based on whatever is the price discovery in the market. Now to add to it this level of unpublished price-sensitive information as something which would contaminate a financing transaction is completely going beyond the scope of what this is meant to cover.
I think they have not thought through the consequences and the profound impact analysis has not been done.
I have a problem with it because actually the regulation, the words of the regulation are fine. I don't have an issue with it. I think it's the note which complicates it, because it's the note which brings the word pledging, which ordinarily would never have
pledge
been.
is not in the actual definition
it's not,
of trading.
because pledge is not a dealing. You're not dealing as on a proprietary basis. You're only taking security.
So unless, Cyril, we go back to the question that we just discussed about the out, that did the regulator intend that whilst there is a prohibition, and it included in the case of a pledge, because if you look at regulation 4 again, that you shall not trade in securities, and if pledging is trading in securities, then the out is your innocence, that you did it for a legitimate corporate purpose, a legitimate business purpose, namely to finance your business. So is that an out? It could be an out, but the problem that I face is that here will be situations where the regulator will keep coming after these organizations and insiders
in multiplicity of litigation,
and it is extremely
not necessarily, sir, because I'll tell you what, if you go to a well-known bank or a well-known non-banking financial company, they're not going to extend money to you on the basis of the shares that you pledge to them unless they see what the legitimate purpose is. So I don't think every pledging transaction is going to come under the scrutiny of SEBI.
It might have been meant to come up promoter financing, but this doesn't have that effect. It may even apply to a case where the loan is lent to a company for its project based on diligence. In the course of that diligence, which every lender will do, they will come into possession of confidential information, and a pledge of the promoter shares will get picked up in this.
Let me ask you a different question that came up actually in the Lever case, whether a company is an insider of itself. You remember that issue?
Yes, because the information of knowledge versus information.
And look at the definition of insider here. So if a company is going in and seeking finance from a bank, okay, and it has to pledge some of its assets or whatever it is, okay, and there may be also shares, then the company itself is a perpetual insider.
Yes.
Fair enough. So this is a serious sort of, pain point that SEBI needs to address. The second one I wanted to bring up is, are you clear on what is UPSI? The other big change is in the definition of unpublished price-sensitive information, or UPSI. The earlier definition said UPSI was information related directly or indirectly to the company, not published by the company, and which, if published, is likely to materially affect the price of its securities. The new definition says UPSI is information relating to the company or its securities that is generally not available, which upon becoming generally available is likely to materially affect the price of its securities. Now, generally available information is defined as information that is accessible to the public on a non-discriminatory basis. The accompanying note uses disclosures to stock exchanges as an illustration, but not a limiting one.
Suppose there's a whole series of sort of news articles or TV shows which
would that make it generally
so long as it is non-discriminatory and it's available to the public.
So
now
that shift is a big shift, because till now it had to be a stock exchange
on an English channel but not a Hindi channel.
This was the shift which happened in 2002 when they realized that based on a Lever's case itself, that they needed to say that only when company has released the information it's available.
Is it generally available?
So they went to pre-2002 situation by bringing it in a manner that now anything which is in the marketplace and generally available would be regarded.
We have gone back to the lever.
Pre-92.
That's what I thought was a big shift.
Pre-2002
So
situation.
three big shifts there.
Because in that case, the argument was that this information about the merger of those two companies was being speculated about in the media every single day, and therefore it was generally available, and you could rely upon that. I think the new definition of generally available information gets us to exactly that.
So now, would an article on some not very well-known website, but a website that anybody or everybody can read, and therefore is, you know, accessible to everybody,
I'm sure Amit, if he is defending somebody, and if that was the case, he would definitely argue that as a defense for sure.
So that's what I'm saying. So that's where my fear came in. Saying the moment you take it away from being a stock exchange disclosure, you open it up into being a lot more.
I think so. Therefore, the important qualitative term here is generally available.
That's right.
And when you actually take this example that you gave, that if it is in some non-district newspaper in some corner of the country, and then you can come back and argue and say that it was generally available, I think it becomes a question of fact, and it will be possible for the regulator to say that that should not be treated as generally available, depending on the quality.
Because generally, the word generally is only part of the definition. It's not part of the explanation.
But I'll tell you what will happen, Cyril, otherwise, and that's where I think the courts will have to interpret this. You can have a device where somebody might actually plant a small little article somewhere in some obscure block somewhere, and then say generally available. So that will become a question of fact.
The test is not generally available. The test is that it is accessible to the public on a non-discriminatory basis.
Yeah, so but the question is that if it is on a blog, then it becomes accessible.
There is no test of availability prescribed over here.
Here. He says that is not, see, UPSI, that's right, that is not generally available, which upon becoming generally available is likely to materially affect.
Yeah. But generally available information means information that is accessible to the public on a non-discriminatory
basis.
So if it is a website,
so the question will be that is
a non-district paper somewhere in the corner of the country, which is actually the paper is generally available to all of us.
That's correct.
On a non-discriminatory basis. Any of us could want to read it. So that would fit this. So just on the basis of that defense, you would slip through?
Yes.
Very strictly speaking, yes. I think it depends on how the courts look at the totality of the facts and circumstances, looks at the nature of the transaction, the size of the transaction, the timing of the transaction, the people involved in the transaction. I think there'll be a whole lot of other facts. In that context, of course, if this is some non-descript blog somewhere which is never accessed, probably you'll find on the hits that only 10 people access that blog.
You'll have to prove malafide.
No, then that's where the burden on the regulator becomes a little heavier to establish that there's a device. Because otherwise it's easy to argue that this is on a non-discriminatory basis because it's available on a blog.
The new regulations make communication of UPSI or unpublished price-sensitive information an offence except in two cases: in connection with a transaction accompanied by an open offer, and where the board of directors is of an informed opinion that that transaction is in the best interests of the company. If the transaction is not accompanied by an open offer, then the UPSI is to be made publicly available at least 2 trading days before the transaction is effected.
You had an absolute defense under the old regulation that if you're going to make an open offer and you come into possession of UPSI, safe harbor, you're home. But they've added a condition over here that it must be, the giving of the information must be authorized based on an informed opinion by the board. That is the board of the company. Now, when you do a deal, Menaka, actually what happens when you're stitching together an M&A transaction, it's ordinarily the management which cooks the deal and then eventually takes it up to the board. It can vary on circumstances, but I'd say 8 out of 10 cases, management cooks the deal and then takes it for approval to the board. What this implies is that the board has to pre-authorize the carrying out of the diligence before the diligence is carried out. So you have to firstly go to the board twice. Then the reality of many boards in India is that if you go with a price sensitive transaction to the board for authorizing diligence, early stage of the transaction, the chances of leakage are really high. So you're going to have corporate India leaking like a sieve.
You don't trust your own board?
I'm talking of a reality.
Okay, that adds some further complications.
So if you can't trust your own board,
Menaka, there's a further practical difficulty here. If the management goes to the board at a very early stage, the board will not be in a position to establish, and particularly independent directors will be able to conclude that the transaction is in the best interest of the company at that stage. So is SEBI going to second guess the commercial wisdom of the board whether the transaction is in the best interest of the company? So at that stage, the board may be completely not ready to form that opinion. And I'm telling you, sitting on the board, many times M&A transactions come at a very, very primitive stage, and then a subcommittee of the board is appointed to go into details of the transaction. And essentially, as Cyril rightly pointed doubt. It's the management team which is driving and which has all the nitty-gritties. Board and the independent directors have a very broad 35-40,000
you bring the cook deal to the board. You don't bring the recipe to the board.
Absolutely.
But the cook deal would involve the investor getting access to unpublished price-sensitive information before the board has any idea of whether the deal is cooked or not. I'm asking you, is that how the process of M&A works?
That's how, but how is board going to opine that it is in the best interest of the company at such an early stage?
Two things: informed opinion, front end of the transaction, huge issue on confidentiality, and I think it's going to seriously affect how deals are done. The second part is coming to a conclusion that transaction is the best interest of the company. What if it's a completely secondary transaction, as it very often is? Why should the board form a view on whether selling by the promoter or a majority shareholder to somebody is in the best interest of the company, especially when a competitive offer is still possible?
If it is a secondary transaction involving the promoter, why should the investor get any more access to unpublished price-sensitive information, which the other investors don't get?
I think that's a fair point, in which case you're saying that in case of a change of control transaction in a major listed company where an incoming investor, say a foreign investor, is going to invest billions of dollars in a company, even if it's a purely secondary transaction, you are telling Mr. Investor that you shall not do a due diligence, because you have to not only do the diligence, but then it is something...
You are not allowed to do the due diligence so far anyway.
Who's going to do it? Which dollar is going to come?
But sir, anyways, it was not allowed till now. Now they're saying we will allow.
It was allowed with an open offer.
You weren't allowed to do due diligence, right?
You were not allowed to do a diligence, but if you had an open offer out, it was allowed to do. It allowed to be done. Now the board has to pre-authorize it and conclude that it's in the best interest of the company. Why should the board form a view as to whether sale by the founder or whoever it is,
from the promoter
to, or it could be a major shareholder, from X to Y is in the best interest of the company, because Z can still come and make a competitive offer.
Let me tell you, the independent directors are already very concerned with what the responsibilities cast upon them under the Companies Act, and now if insider trading regulations are going to cast an additional responsibility to come to a view that it's the transaction is in the best interest of the company, trust me.
Okay, I get it. The very first one is a deal killer according to you.
It's a deal dampener for sure.
Yeah, is a deal dampener.
We all find ways around.
It's still true practicality. 2 days before you are going to announce
that's on the second. That's where there's no open offer.
I thought that's where you will have the real problem. I didn't know you will have a problem
on both. I have a problem on both. And
the second one seems to be a little difficult. How do you make it practical to disclose?
I think we will be the only country in the world where we will have a requirement that before a confidential deal is signed, you have to put it out in the public domain 2 days before.
You don't have to put the deal out, but you have to put the UPSI out, and I'm supposing that in itself is ringing an alarm bell.
Which is effectively everything is out in open.
Well,
you have to effectively put the deal out.
Or you have to work your timelines in such a fashion where you put the UPSI out.
2 days.
2 trading days.
But many weeks in advance of the deal actually getting closed, so that nobody actually is suspicious.
Are you encouraging people to game the system?
No, you're not. You're saying that information should be available. In the case of an open offer, retail shareholders get an exit, so therefore you getting access to UPSI being an unfair situation is mitigated in some fashion. In the case where there is no open offer, nobody else is getting an exit and therefore benefiting from that price discovery.
The distinction about the deal and the unpublished price sensitive information is a very thin distinction.
Mr. Desai, you've been silent all through this.
And I must tell you that this is a matter of great concern, because in any deal making, as I was mentioning to you earlier, it says very often a deal has to be done on the basis of an average market price for the previous few weeks. You disclose the UPSI 2 days in advance, it changes the market dynamics, it changes the entire deal structure. So, and the second is that the other question would be that when do you make the disclosure of the deal itself? Because what you're saying is you don't have to make a disclosure of the deal, you have to make a disclosure of the UPSI. Under the listing agreement, if this has to be done 2 days before the proposed transaction, the exchanges are going to say that the deal was complete, you had a duty of disclosure so far the deal is concerned.
The existence of the deal itself was price sensitive.
And the existence of the deal has to be also disclosed at that point of time. Because you're going to have the situation so far as the listing agreement is concerned.
So if
I thought legitimizing the communication of UPSI in the cases of investment related due diligence was actually one of the good things that this code does, or this new set of insider trading regulations does, because all this time due diligence was illegitimate, so to speak.
You're saying in both, but the way they have drafted it is made almost impractical, completely impractical. And I tell you, there are many such unintended things. One classic thing I would point out is that they use the definition that whatever terms which have been used in these regulations but are not defined here, you can use the Companies Act definitions. They use the definition listed company, which is not defined here, Under the new Companies Act, the listed company means unlisted companies whose debt securities are listed.
So even if just your debt is listed, you are a listed company.
And it will be subject to the entire discipline of the new regulations. I don't think this was
intended. So if you're a holding company with listed debt, but you're an unlisted holding company, as in your equity is not listed, you would still be subject to insider trading. But what is wrong with that, sir, if there could be insider trading that took place even with debt securities? They're only simply saying whatever the security, if there is a marketplace for the security and other investors for the security, we have to protect.
I can't visualize many situations.
But they are also only if you're talking about the listed debt security. But the effect of what Bharat is saying is that once you become a listed company, because of this, then even your shares which are unlisted will get covered under this.
Will the equity shares get covered if only your debt is listed?
Security of a listed company. It's a listed company.
But how can you in an unlisted company have unlisted equity situation have insider trading?
This point has already been lost in the Companies Act, because in the Companies Act also it has private companies are covered by this.
So that's the problem, that because they use the definition under the Companies Act, it is unintended consequence which I don't think they have thought through.
Like in the US, India too has now introduced the concept of trading plans, affording a perpetual insider like a CEO or a CFO the opportunity to buy or sell his company's shares in a predetermined fashion. The conditions include a 6-month cooling off period before the trading plan can be activated, a maintaining of the closed period around financial results, a duration of at least 12 months, and details regarding the value of trades or the number of securities to be traded, along with the nature of the trade and the trading intervals or the trading dates. Curiously, the regulations also say that a trading plan cannot commence till the UPSI with the insider is made generally available.
I think the concept of a trading plan is a good inclusion, but the way it's come out, I don't think that even one person is going to use it.
Why is that?
At least for the number of reasons, but I think one reason is the fact that once you have announced a trading plan, then you are required to commit to it, and that you will in fact perform the trading plan on the dates that you say, regardless of any change in circumstance. That is point number one. Point number two, I think, is that there is an intellectual flaw in the fact that you, having announced a trading plan, if you still have unpublished price-sensitive information, you would be entitled to implement your trading plan. The whole purpose of a trading plan is to actually sort of ring-fence yourself from possession of unpublished price-sensitive information. So if UPSI is still going to contaminate your decision to implement the trading plan, then what's the point?
Absolutely. No, the very objective was that there are people who will be perpetually in possession of UPSI. So you said that no, but if you are in possession of UPSI, you can't implement the trading plan. So there's a contradiction in the term itself.
They're saying you have to push your trading plan till you have disseminated the UPSI.
But I will still have a UPSI continuously because I'm supposed to be a person who is perpetually in possession of UPSI.
So it's Menaka is like saying you're a perpetual insider. So I'm giving you this avenue of a trading plan, which you must not only must implement, but if you still have unpublished price-sensitive information, you can't implement it. So it's a double negative.
Aren't they saying maybe it is UPSI which is slightly more urgent of nature? This is for argument's sake.
Where do you get all that?
For argument's sake. Suppose you know a deal, no?
The 5 conditions which are annexed to the trading plan, I tell you, I will assure you not a single transaction will happen according to trading plan.
Nobody will be able to use
I think the closest thing that comes to what you're saying is a proviso to sub-regulation 4 in whatever that section is. It says implementation of the trading plan shall not be commenced if UPSI in possession of the insider at the time of formulation of the plan has not become generally available. To take an example,
if you know a deal is going to happen,
mega deal is going to be done with reference to this company and that information is continuing with you, you shall not do it. But this is almost always the case, that you have such
you're not always in the middle of a deal or in the middle of an asset sale.
It allows you an out for short-term UPSI, but for something which is more structural and
so
strategic.
The magnitude of UPSI, right? If you knew, so I get it. It's not written in there, and I understand if it's not written in there, there's no point all of us speculating.
If you actually want to hang somebody on this, you'll always find something which is in the mind of that perpetual insider, which you can.
So nobody will use the trading plan because they will always be fearful of the fact
using this unless this is changed.
I don't think we don't believe that it would ever.
And you will not be able to defend anybody who uses this trading plan.
Extremely difficult.
Okay, we've covered broadly some of the salient features of these new regulations, an expanded definition of connected person, a shift in the burden of proof, several more defenses therefore.
One jumbo defense.
One jumbo defense as you've called it. Some definitional issues that continue, mostly with what is a listed company, as Mr. Vasani spoke about, the issue with UPSI and what is generally available and not generally available. due diligence, which was supposed to be a good opportunity that these new regs offered, which both of you, all three of you say will actually just be deal killers. And then finally trading plans, which were also supposed to be the other big good opportunity that these regulations offered, which you say nobody will use. So at the end of all of this, do we have a regulation that makes it easier for the regulator to go after the real crooks? Is this an improvement on 1992?
Well, I think the time will tell. I wouldn't be able to prejudge this right now. I would say that perhaps some of the things, unintended consequences of some of the things which are drafted now, will be in 2 years' time it will realize. I think that this code is in for a significant revision within 2 years.
My guess is that, Menaka, I think the judiciary will have to really evolve principles around this to achieve the real intent. I don't think it's achieved by the language of this. I think the regulator will of course do their bit according to how they understand the law, but SAT and the court setting will have to really restore the balance on this.
But I think that's going to be a little difficult, because ultimately the courts can only interpret the regulation.
Right.
And when the context of interpreting the regulation, the jumbo defense that's available becomes a question of fact. So you can't take away the fact that this defense is very much in the regulation now, and every time the regulator will have to now have a heavy burden to try and discharge to show that it was a case of insider. So whilst my view is there will be a lot of files that might open up, you may not get adequate relief at the end of the day.
All right, gentlemen, we're entirely out of time. Thank you very much to all three of you for joining us. Insider trading is a really tough offense to catch everywhere in the world. So let's wish SEBI best of luck with these new regulations. With that, thanks very much for watching. We'll see you next week.